late April afternoon. So today we're going to talk about terminations, and I typically get one or two of these as a question or a problem. Maybe 4 a month, maybe one a week, something like that. So it comes up pretty often. And we occasionally talk about it, occasionally a fight, but so I just want to review all of that today. I don't think it's a terribly complicated subject, but there's at least one important distinction to bear in mind as we're talking about that, and that is this, and that is the distinction between a termination and a release. And the distinction is really very simple. One is unilateral and the other is bilateral. So a termination is a unilateral act. That is, one party says, I'm terminating this contract, it's over. A release, on the other hand, is where both parties, that is, it's bilateral, both parties agree that the contract is over and at end. And as we'll see in a little bit, there are other things that are addressed when the parties agree to release or resolve the contract. So, you guys experience really on a daily, weekly basis, certainly monthly, some of the common terminations. I don't think we see it that much, but under the Real Property Disclosure Act, the buyer has a right to terminate the contract if the buyer was not provided the VREB disclosure under the Real Property Disclosure Act. And so there's that common VREB form, but there's also that should be appended to every contract, and that disclosure is required prior to the buyer signing. But within that act, there are also that's where you get the defective drywall, meth, and the military noise disclosure. So there are a number of disclosures that are required under that act. And if they're not provided, the act is very clear that the buyer can cancel or terminate the deal. So I don't know that happens a lot, but that still exists. Of course, the most common basis for termination is under the Property Owners Association Act. We all call it the HOA Act, but it's really the Property Owners Association Act. And so you guys are familiar with this. This arises by statute under Virginia law, regardless of whether it's in the contract or not. And so that basically says that the buyer can get the, and we do a whole class just on this because there's always lots of issues and problems. But fundamentally, the seller has a duty to get the package from the association provided to the buyer. The buyer then gets 3 days to review it, and the buyer can terminate or cancel the contract for any reason or for no reason. The statute and the case law is very clear about that. And then, of course, the other thing is a buyer can terminate any time prior to receiving it if it's obligated. In other words, you don't have to wait. A buyer doesn't have to wait to actually get it before terminating. So, again, just to kind of reiterate the distinction between termination and release at this point, under the Real Property Disclosure Act, the buyer just has a right to terminate. The buyer doesn't have to get the seller to agree to that. Same thing under the Property Owners Association Act. The buyer gets the package. The buyer has a right to cancel or terminate the contract, whether the seller agrees with it or not. Some of the others are a little more complicated, of course, and they're not arising out of by Virginia law. They're arising out of the language of the contract. So these first two that I've listed, that's by statute. It's also in the contract, but it doesn't really matter whether it's there. These others, they're arising because language in the contract gives a party the right to terminate. And this has changed. I think Liz and Donna would agree with me on this. This has changed a lot over the years. I think the association contracts, when I first started practicing, the word terminate didn't appear in the contract at all. And, now it's very common in all the association contracts. Searching through the CVR contract, for example, I think the word's used 22 times. So, there are a lot of provisions in the contract, and you just need to familiarize yourself with them about a party's right to terminate. So, you guys are pretty familiar with the home inspection contingencies and how that gives a party the right to terminate. And each of the contracts is different, and CDR is very different, for example, and how home inspections and what can be requested and how long you need to negotiate, or whether you have to negotiate, and whether you have to disclose the home inspection report itself. I mean, that all varies, but at the end of the day, if the seller won't make the repairs required by the buyer, then the contract's going to end up ending. And in at least a couple of them, parties specifically given the ability to quote unquote terminate the contract. Appraisal. Well, we all think about it in terms of financing as a contingency, and it doesn't appraise, and that clause is in the contract. Well, the contract's going to end. But again, two of them, I think all three of them specifically talk about a party's ability to terminate. So you don't, in that situation, you don't really need the other party's agreement about it. You're just going to follow the language of the contract. The same thing is true in financing, and this is primarily in two respects. The contracts do talk about if the buyer doesn't do a certain thing by a certain date or in a certain way, the seller has the ability to terminate the contract. Likewise, of course, at least two of them talk about the buyer's ability to officially terminate the contract if the loan is denied. So, this really doesn't come up that much, but bear in mind, termination authority also exists under the financing clauses. In the RAIN contract, for example, there's a specific, we've talked about this many times, if the deal isn't closed by the specified date, then the party not causing the delay, or the party not responsible for it not closing, has the ability to officially terminate the contract. All the contract, well, at least BR and RAIN have a version of a repair cap, and with specific ability to terminate in the event the repairs are of a certain, beyond the cap or that kind, or somebody's not going to pay for it, that kind of thing. All the contracts give the seller the ability to terminate expressly the contract if the deposit gets messed up, if the check bounces, that kind of thing. Title, there are provisions in two of the contracts that talk about a party's ability to, really the buyer's ability, but also in the VR contract, the seller's ability, for example, to terminate the contract under certain conditions in the event clear and marketable title can't be conveyed and it can't be fixed within, say, for example, 60 days. The contracts also contain provisions that say if a party has misrepresented something, and there's that long list, particularly in connection with financing, but there's also bankruptcy and third-party approval, that kind of thing. And if there are misrepresentations by a party in the contract, then there are specific provisions saying the other party can terminate. So, the idea, both with the two statutory mechanisms or avenues for termination, and then with the balance, and I don't think this is even exclusive, although I looked through all three of the contracts pretty carefully. The idea here was, and I mentioned that at the beginning, at least when I started practicing, I'm not sure that that word really appeared anywhere, although we still had financing and appraisal and the like. But the reason it's there now is to provide some clarity to all of us, to avoid that situation where you're sitting there saying, well, what do we do? Do we still have a contract? Are we supposed to wait till closing? What's the deal? So that's really the genesis behind all of that. And I think that helps a great deal to make it clear. Unfortunately, it isn't always clear. And that's why, Liz and Donna and Tanya, and, we're all getting 3 or 4 questions a month about this. Is because, even nothing's ever all that clear. If it was all that clear, I wouldn't make a living. But before we get to those problems a little bit, so how do you terminate? This has gotten a lot better over the years. For the longest time, none of the associations had a termination form. They now, we're going to look at those. So all of the associations now have a version of a termination form. And so and we'll take a look at them. And so the idea is that, if you've got a right to terminate by statute, by contract, then, you as, say, for example, the buyer are going to send notice. You're required to do that. And you need to follow how the notice is to be sent, both in the statutes and in the contract. But, your client's going to give notice to the other party that they are terminating the contract pursuant to section or paragraph or whatever it is. And you send that to the other side, and that's the end of it. That's how you do it. And if you ever find yourself in a situation where it's somehow really hotly contested, reach out to your managing broker, and then perhaps me, or they'll get me, whatever, because we want to make sure that the statutory mechanism is appropriately followed. And that, because it's very specific about how you do it, and that's really applicable to these two.
Brian, can I chime in for a minute?
Yeah, sure.
So one of the most common mistakes I see about this is an agent just sending an email that says, I'm attaching the release. There is no, my client is terminating the contract. I see that all the time. I think that that's where the agents get confused between the difference between termination and release.
All I can say is bad agent, bad agent, because, as Liz is, and I'm saying that with a loving smile to everybody, because we have no bad agents. But no, that's wrong. When the contract or the statute says you give notice of the buyer can terminate, you have to give notice of the termination, and notice of the termination, particularly pursuant to statute or even the contract, isn't number one, just sending a release over, because you're not specifying that you're terminating and the basis for the termination. So I think by any definition, that's not an appropriate notice. Now, what I think happens, so we're kind of down here under how to terminate. And so that's how you terminate. You use the form, you fill it out, you say, and well, let's just go to one. So let's go to, here's the RAIN termination. So you're filling in the parties, referencing the contract here. But, sellers do have the right to terminate, as we've noted, but let's say this is a buyer termination. So it's being checked by the buyer. Undersigned's terminating the agreement pursuant to the, Property Owners Association Act, paragraph, whatever of the contract. They sign and date it. And if I were an agent doing this, I would send it by email. And not only to the listing agent, if you have the seller's email addresses, I would include them in that. Normally you don't communicate with them, but I would do it there. I'd copy the settlement agents, and then I'd also fax the thing and make sure you get a transmittal memo by fax. If you do that, you're going to have satisfied both the contract and the statute. If you don't want to include the other party, that's fine. I don't know that you necessarily need to do that. My only concern would be, some of the stuff talks about obviously sending notice to the seller or, the other party. And then, you could get into a situation whether there's argument that notice to the agent is notice to the party. There's that language in addenda dealing with the Property Owners Association Act, which says is the agent entitled to receive it? So I suspect there's a lot of gas or a little anxiety by everybody watching, because you've probably been through this, and I'm sure no one has ever included the other party in the email thread. Well, obviously that works out, and we've never had a lawsuit or a disagreement about that. But if you're asking Brian the lawyer, or if Brian the lawyer on a contract not involving you guys were to send a notice of termination, that's how I'm going to do it. So that's how you terminate. You send the termination forms. That's a release. CVR's notice of termination. Similar. You're putting this stuff on. You're saying who's terminating. You're checking the blocks. I'm going to come back to important information regarding this. Let me see. I think I've got VR's termination. No, VR does not have a termination form. Is that right? I think Liz is saying nodding her head yes.
I think that's right.
Yeah, so I reached out to make sure I had all the forms, and I'm thinking I was told. So you guys have clearly been doing this. So there's either a company form or some version of that that you guys are using to terminate on a VR contract.
No, that would be an email. So I'll put company form on my list.
Company notice of termination.
Actually, I think even in Williamsburg, we're using the RAIN form.
Wasn't that in a different class where we talked about not using mixing forms?
Yes, sir.
Okay, well, with that being said, as I look at this, you could probably make the RAIN form work without any real risks. But we can come up with a company form if that's what you guys want to do. So that's how you terminate. Obviously, I'm going to tell you, don't send the simple, email. Do it the right way. I can't give you any different legal advice other than to do it that way. So, the question inevitably comes up, well, what about the deposit? And that certainly can be an issue, because, so here's the deal. Certainly in these two statutes, the Real Property Disclosure Act, the Property Owners Association Act, and then I think the language is mirrored in the contract, and actually on most of these contractual termination rights, the statutes definitely say, and when the buyer terminates, the deposit is to be returned to the buyer, period. That it says that. Most of these provisions in the contract also say, and the buyer is entitled to a return of the deposit. So the buyer is really entitled to a return of the deposit, whether a release is signed or not. However, as a practical matter, and the way the practice works is that either the termination is being coupled with a release so that everybody can reach an agreement about the deposit, or I think maybe the most common thing is a release is sent, and in the body of the release, it says buyers terminating under the Homeowners Association Act. Not, should be Property Owners Association Act, but we all know what you mean. And that works. We haven't had a lawsuit over that, and that can work. If the language is specific enough in the release that a judge looking at it later or someone else can clearly see that the buyer is exercising their right under a particular contract or provision of the law to terminate, and they're just doing it in a different form, I think that's going to be okay. I would certainly defend that. If so, again, the funny part of this, and this is just Brian being the lawyer for the brokerage, is there's, okay, which lawyer Brian hat am I wearing today? Am I wearing the Brian is going to tell everybody to do the thing in the manner in which you can never, ever get sued? Or am I wearing the hat that says, look, be practical, would you? Realize how busy we are and how things work, and don't make me do all of that. Okay, I try and wear that second hat almost all of the time, and I'll try and make the distinction and give you the answers under both hats. Under the first hat, I want you to send a notice of termination accompanied by a release. That's easy. Well, I mean, I say it's simple in concept, let's say it that way. And then no one can argue that you haven't done what you're supposed to do. Lawyer hat 2 on, where I recognize that the way this is commonly done is by sending a release that has language about termination. Okay, that seems to be working, and it's easier. It's one less form. Just be clear in your language about it, that, use the magic T word, say terminate. And, we'll all bear in mind that it's okay. The only time I would really caution you is, when this is, you've got a really bad deal with a difficult other party and you're anticipating a problem. And if those are the circumstances, then you do it dotting the I's and crossing the T's, and you do it perfectly. If everything's okay, then, a lawyer hat 2 option is pretty good. Lawyer hat 3 is Brian turns a blind eye and says, what the heck? But I don't call you out on it. And that would be Liz's question, where you're just sending an email with no forms, no termination language. But even then, I guess it seems to be working out, because we're not getting sued in VREB complaints on that stuff. But
That's because the other agent doesn't know either.
Yeah, well, that's possible.
And Brian, Brooke has mentioned in chat that all 3 associations do have termination forms.
Okay, the one I don't have, and I apologize then, is I don't have, I know CVR does. I showed you that one. I've shown you the RAIN. Maybe WAR has a separate form. Maybe VR has one, and I just don't have it. They're all going to be very similar.
Brian?
Yeah.
Can I say something? I think when it's a situation, especially when we're on the list side and we are strategically terminating because we've got another offer we want to take, so we are past the date in the home inspection contingency where we can terminate, or if it's under the loan paragraph for the buyer, I think the agent needs to clearly state the termination before they send the release.
Yeah, I agree with that, because number one, you should know under those circumstances, the other side isn't going to sign a release, right?
Correct.
Correct. And so, to go back what I said before, one good test for that is, do you think the other side's going to sign the release? And you're going to know. It's difficult, or you should know probably. And so if you find yourself in that situation, then, as Donna mentioned, that's under lawyer hat answer 1. You do it, notice of termination accompanied by a release. We don't want to, and this can happen for a buyer pretty easily. You give an ineffective notice of termination, you're beyond 3 days. The other side says, sorry, you didn't do that. You didn't properly exercise that. Then what are you going to do? Go back, tell your client, well, I was busy. I just did it from my phone and I didn't really have time to do it properly. Sorry, you got to buy this house. That's probably not going to go over very well. But anyway, so that, and so that's why, we do the releases, is to make it easy to get the deposit refunds. And then, of course, when the parties sign the releases, we know it's over. You don't have to wonder about it, because the parties have agreed it's over. So, that's why you accompany it with a release. And that's why many agents kill 2 birds with 1 stone and just do it all by release. And so, I thought the CVR form was kind of interesting. So there's a couple of notices. And, the first notice is, reminding the agents really that to be effective, it's got to be deliver this notice to the notified party. You see this language, authorized agent. And so that's where I was reminding you earlier. I'd actually include the other party in the email to make sure that they can't come back and claim that you weren't authorized to send it just to the agent. And then, of course, the manner or mode of delivery, email and fax. Fax is specified under all of them, but electronic means is specified under most. Now, what I thought was interesting, okay, this language or this notice of termination is not a substitute for a release. I certainly agree with that. Although I don't know that I would agree, or if it's implying that a termination in and of itself isn't sufficient, because it is. The other thing is, nor does it authorize a disbursement of any earnest money deposit with the language in order for both parties to be released. I agree with that. A release or other written authorization must be executed by both parties, delivered. I don't think that's really true. I mean, for example, the statutes, Virginia law is going to trump. The statutes are very specific that the deposit is to be released. I don't really think a broker needs any further agreement from the parties in order to legally and properly and to be obligated to release that. And one of the statutes, for example, the Real Property Disclosure Act, kind of talks about that. It uses those words differently. Now, let me put my other hat on, which is, Donna calls me and says, hey, I'm holding the deposit. There's been a termination, but somebody won't sign a release and objects to the release of the deposit. Can I release it? Well, I'm probably going to say no, notwithstanding the fact that I've just said legally, I think the broker can and probably should. And that's because anytime you've got an objection from the other party, I mean, we don't want to have the brokerage sued just because. So be very careful about that. I won't say that under some circumstances where we're holding the deposit, I wouldn't, if I'm asked, authorize a release of the deposit without a signed release of the parties, to be clear. Nor is that, so if we're on the flip side of that and the other broker's holding the deposit, our client has terminated, but the other side won't sign the release so we can get the deposit, I'll probably argue with the broker. But at the end of the day, I don't think I'm going to be that mean about it, because I just told you that if Donna were asking me what I would tell Donna. So, that broker's in the same or similar position, and we need to be mindful of that. I do try, we're going to be an advocate. I'm going to be an advocate for our clients and for us. But, on the other hand, and Liz and Donna see this all the time, but you guys might not. I've been doing it a long time, and certainly on the peninsula anyways, I think most brokers, I'm counsel for the association, I think most brokers, when Donna and Liz say, hey, well, I asked Brian and Brian said, that carries some amount of weight, but that weight is only going to be as good as me being consistent about the kinds of things I say. In other words, if the other brokers know that Brian will just talk out of both sides of his mouth, depending on which side he's on, if that's always the case, then I'm never going to be able to persuade them. But if, and Liz and Donna have seen this happen, and maybe you guys as individuals in your own deals, but I know Donna and Liz and I have seen it many, many times where, me saying something counts. And when they ask me and, I say one given thing and it's maybe not what Liz or Donna wanted to hear, we'll typically let the other side know that, as long as it's not really harming our client. And that has really worked well for the company over many, many years. So that's kind of that's a long explanation for how I view deposit refunds. But that's not to say that we can't press and try and persuade another broker to release a deposit without a release. I'm just saying I'm not going to threaten to sue them or refer them to the board or something like that if they won't. Because if I were defending Liz or Donna, I would be saying, taking the exact same position they are, probably. So,
Well, and guys, I need to say, even though Brian is saying all of that, if I feel strongly that we have a contractual right to release the money, I'm still not going to do it without Brian's blessing.
yeah.
It's just what Liz and I do. So.
Yeah, so
Prepping you.
So Valerie has asked in chat, do you mention anything about asking for the return of the EMD deposit in the document? So Valerie, I'm not sure if you're referring to just if you send the notice of termination, if you're saying asking for the return. I don't think I would ask for it. But, I might, for example, send a notice of termination that says buyer is terminating under the Property Owners Association Act, C paragraph, whatever, 7 of the contract, whatever it is, period, pursuant to that paragraph in Virginia law, buyers entitled to a refund of their deposit. Within 30 days, I think one of the statute even gives a time period. I'm confident it is. I just can't remember if it's under the Disclosure Act or the POA Act. So I don't know if that answers it, Valerie, but the common way that it's done is to send both forms. Send the notice, and I'm perfectly okay with that, and that's fine, and that's probably the best way to do it. You send the notice of termination. Concurrently with that, you send the release, and the release is going to deal with the deposit.
Yeah, I asked that before you kind of went into more detail. So, yep, I think we're good.
Are you taking after Liz and asking questions I'm about to address? Is that
Sorry.
Brian, what happens when the seller wants to put the house back on the market?
Oh,
Sorry, I couldn't resist.
yeah, I know. So following up on Liz's question, what about breach, relistings, new offers? So that comes up all the time. What about breach? So what do I mean? So let's say the other side, hold on, Shirley, I'll get with you. So what about, that's on page 2 of my outline, Shirley. What about breach? A situation where there's not an explicit right to terminate. It's just the other side's in breach. They won't close. You can't get them to do what they're supposed to do. Well, what do? Can you terminate? Well, that's actually a little complicated because, we've talked many times about the idea of a material breach. I think it was 2 classes ago we talked about this. But, what about, there's a difference between a material breach and a non-material breach, and in a material breach that excuses, one party's obligation to perform. So I think there could be, in a material breach, there could be some circumstances where if our client, I'm going to say our client, because this is always the case, our client has done what our client is supposed to do. It's the other side that's the problem. And the other side is in material breach. Now, if our client, under those facts, they don't care about suing, they don't even care about the deposit, they're just so over it, and they just want to move on. Under those circumstances, I might, now this is, you got to let me weigh in on this. I might say, okay, let's have our seller or our client, could be buyer or seller. Let's have our client send a notice of termination because of a material breach. I would probably want to draft that, or at least give you cut and paste language. I probably want to talk to the clients in a conference call or something like that to explain what we're doing and why, and how somebody might disagree with it. But I think that's what I do is, if we say that on a material breach, you have the right to not perform, we don't care about damages, we don't care about a lawsuit, then we're gonna terminate. It's just it's a different kind of termination. That's why I think I need to be involved.
And that's really important, guys, because I hear from you a lot. The seller's over it. I'm going to put the house back on the market. It's not that simple. And in that kind of a situation, I do want Brian to weigh in before we just reactivate the listing.
So, which leads us to, relistings, buyers writing new offers. All right, so here's kind of the idea. Relisting, for example. So a seller has a right to terminate, and a seller has terminated. And now they want to go, but the buyer won't sign a release. So now the seller's question is, can I relist after I've terminated, but the buyer doesn't think my termination is proper? So the risk there would be that the termination is not proper, and the seller ends up with 2 contracts on their house. So, and then I get this all the time, where the other side says, or somebody says, you cannot relist property without a release. It's like illegal, or you'll go to realtor jail if you do that. Well, they're just making stuff up. There's no law that says that. There aren't even any MLS rules that say that. That's just not accurate. I'm not saying you might not get pushback somewhere, but that's not a law. I mean, if that were a law, just think of the circumstances where you have disappearing buyers or sellers, which happens. We've had that happen any number of times. I don't know what happens to these people. Maybe they're going to be in a documentary in some crime murder mystery, but we have people who just disappear and we never hear from them again. So what does that mean? Our client can never, ever list their house for sale again? Well, that's obviously not true. And not only is it not true in Brian's crazy fantasy land example, that's, I think, kind of real in Brian land, but it doesn't even work for real stuff that happens on a day-to-day basis. There's just no law that says that. When I look at it, and it's really under hat 1, 2, or 3, I'm thinking, okay, was the termination proper? Is there really any risk for our client? And, once I kind of work through that with the agent and the parties and the broker, and I talk to the client about it, I'm going to say, relist it. And then I'll just deal with whatever knucklehead out there that thinks we can't do that. But, that's something where I got to have some eye contact with the seller, because for all I know, the knuckleheads on the other side are going to file some lawsuit or something like that. And we need to be careful about it, because, if so, say, for example, in a listing, if the buyer's side, the buyers are saying, no, your termination is not proper, we're not signing a release. Okay, well, I do think that I'm the smartest guy in the room, but I'm not that conceited, I guess that'd be the right word, to think that, well, I could be wrong. And I've got the other side telling me I'm wrong. So I'm going to think about it, and I'm going to be careful with our clients. And so I might suggest that, any offer that's accepted be contingent on a subsequent release, or there not being 2 contracts. And then you and Liz and Donna are going to say, but Brian, that hurts the marketability. And you're going to badger me until I agree that you can list it without having to put something in a contingency. And we'll get there. And what I typically do is I will challenge the other side to tell me why they think it is we're wrong. And when I do that, it usually goes away. The flip side of that, where a buyer has terminated, the seller won't sign the release, and the buyer wants to get on with the process of finding a new house. And worse for the buyer, the seller's refusal to sign a release is probably almost certainly going to result in the buyer not getting their deposit back right away. Well, it's the same sort of situation. We're going to look and see if the termination is proper. I mean, we have had circumstances, for example, where a buyer terminates under the Property Owners Association Act, the docs, the HOA docs. It's within 3 days, it's done proper. And the other side just will not sign a release because the seller's mad. The seller's mad for whatever reason at the buyer, and they just won't sign. Well, the law in the situation is very, very clear that the buyer has a right to do that. The buyer's entitled to get their deposit back. And here's a case where if I say, okay, when you write this new offer, put language in there, it's contingent on the release of such and such contract. I know you're rolling your eyes at me and saying that's not humanly possible. It's hard enough to get an offer accepted. If I put that in there, no chance. Okay, I get that. And we'll work through it. I just need to do these really on a case-by-case basis. I need to try and make sure that the termination is proper, evaluate that, have some discussion with the clients, and then, advise you guys and the clients accordingly, and then the client makes a decision. But we're going to work towards relisting and writing new offers. And this notion that you have to have a release in order to do that is just not accurate. We just need to be careful about it. So, did I cover that okay, Liz, Donna? Anybody have questions? Want to pop in with that? I'm getting near the end, so this is your chance. Okay. Shirley's asked, so what do you do with the EMD that neither side agreed to release? All right, so trivia question for Donna and Liz. What's the oldest EMD the company is holding? Do we know?
I have no idea, but I know we have some old stuff.
I mean, like this is in like years old, right?
Mhm.
Yeah. Well, so Shirley, I'm not sure if you're really asking from the standpoint of like, Lana, bookkeeping headaches, what the heck do we do? Or more, you're involved in the transaction and you just can't, what are the options? Let's put it that way. So a broker, the statute, the VRB regs detail how a broker handles that. You give notice, you entertain written objections. And then, at the end of the day, there's something called interpleader, where you can file a lawsuit that says, Judge, I'm holding this money. It's not mine. People are fighting about it. I'm not a party to that. I don't know who's right. You decide. It's called interpleader. And the lawsuit is brought against the people who might claim an interest in the property. In our context, that's buyer and seller. You write a check to the clerk of court, and then you're done with it. And you let them fight about it. So that's possible. If you're one of the parties, you're a buyer, and you've terminated, and it's under, say, for example, the Property Owners Association Act, we know it's proper, and the seller won't agree to it, and the listing broker maybe is holding the deposit, or us, the selling agent broker's holding it, and we're just under the threats from the other side. We don't want to take it upon ourselves to release it under those circumstances. Then the buyer goes to small claims court, files a lawsuit for the deposit. I mean, that's what you do. Now, of course, before that, I can get involved and we'll argue about it and see if we can't persuade everybody to do it. And I don't think we've ever had, to my knowledge, a buyer or seller, in some small claims sort of context actually sue for a deposit. So it tends to get worked out. I won't say there's not some angst for a week or two, but it does tend to get worked out.
Brian, I have
Yeah.
a question. I've had a couple over the last year where there is dispute and the title company's holding the deposit. What can I do?
I guess I need to take a look at it. So the VREB regs and Virginia law that applies to real estate brokers really isn't applying to like Lytle title or any other lay settlement agent or lawyer for that matter that's holding the deposit. And I'd have to look and see how the contract's written, because some, at least one or two of them, I think, are written by specifying in effect, somebody that, the regs are being copied into the contract. And by doing that, I think if Lytle title's holding the money, for example, we've probably agreed to hold it as though we were a real estate broker. So I would probably follow the same protocol, but I might be a little bit more willing to release it unilaterally if the language is met, clearly entitled under the contract, how that language reads. And then, of course, the other thing is, it depends on how much the deposit is. So the risk is we, make I mean, nobody's doing anything intentionally wrong, but we misinterpret the law, the contract, whatever, and we get sued for the deposit, and we're at risk of that. Well, part of it depends on how big the deposit is. I mean, if it's $100 deposit, then you're at risk financially of $100 if you're wrong. That's a lot different than if the deposit's $10,000 on a cash deal, and so you're at risk for $10,000. So it's always cost benefit, risk reward kind of analysis. But Donna, to specifically answer it, if I did not, I've just got to look at the circumstances to see under that particular contract whether the lay settlement agent is holding it really without any terms at all imposed on them, or whether that particular contract is written in such a way that they've taken and are holding that contract under the same provisions that a real estate broker would be holding it. Does that make sense? Does that answer it?
Thank you.
Anybody else? Liz, anything else? One thing I did want to, just before we close it up, on release agreements, this has changed over the years. It used to be that all the release agreements also released the parties from any commission claims by the brokers, by the agents. And now they all say expressly that it does not. I just need you to be mindful, and that's okay. I just need you to be mindful of that, because if you're in a really hotly disputed, contested fight about it, somebody's, the seller's getting the buyer's deposit, I would really want the other agent to also release our client. I don't want to make a mountain out of a molehill, because, I always try and ask myself, okay, Brian, is this a real problem? How many times in the last 17 years, 6 months, and 3 days and 4 hours before our anniversary, Liz. That's just totally wrong. I made that up. I'm sure you all realize that. Anyways, I don't think I've ever seen a lawsuit for that, although there's been a few circumstances where I insisted on the language, and maybe that's why we haven't. So I don't want to make a mountain out of a molehill, but I just want you guys to be mindful of that. And if you're in that kind of circumstances and the other agent is so mad that even though the buyer and seller agree to release each other, just in the back of your head, reach out to me or Donna, Liz, whomever. Do we need to think about having the other side also, the agent also release our client? So I think you guys all know that about the releases, but just be mindful of the circumstances where we might want to go beyond the language of the form. So with that is my Get Smart class on terminations. Unless anybody else has any other questions, I appreciate you guys joining in, and I will see you next week. Y'all have a great day.
Thanks,
Thank
Brian.
you, Brian.